if you're a woman getting divorced in Scotland, then this is the video for you. I'm Kerry Griffiths. This is the Willow Brook Lifestyle Financial Planning YouTube channel. And today I'm joined by an amazing guest. I've got Judith Higson from Scullion Law, and she's going to talk to us about the key differences between divorcing in England and Wales compared to Scotland. Welcome, Judith. It's wonderful to have you here. Do you want to just introduce yourself and tell us a little bit more about you?
Yes, of course, absolutely. Thank you so much for inviting me on, Kerry. I'm delighted to be here. So I'm Judith Higson. I'm head of the Family Law Department at Scullion Law. We have offices in Hamilton and Glasgow. I'm an accredited family law specialist, an accredited child law specialist, an accredited mediator, and a collaborative lawyer. And I've been doing what I do for coming on 20 years. So it's been a while now. And yes, I'm delighted to be here. So thank you so much for having me on.
Thank you. And what a skill set. It's quite unusual to find a collaborative lawyer, actually. So I'm one who's mediated too. So loving your skill set. But what I really wanted to talk to you about today, Judith, is how things differ, what the key points are that women who are getting married in Scotland should be aware of. And the reason that I think it's particularly important is because this particular YouTube channel has a lot of content on there that is applicable in England and Wales. And it would just be good to kind of have those alarm bells and just those little points there so that those who are in Scotland are aware of what might be slightly different. So could you give us a bit of a whistle-stop tour, please?
I can certainly try. So I will give you a whistle-stop tour of Scots law. I can't advise on English law, so that's the limits of what I'll be able to do today. But the starting point in any divorce or separation is that we look at the date of the separation. And that's a really important date that we have to identify at the very beginning. And we talk that through with you and we look at, well, what are all the facts and circumstances? Sometimes that date can be really clear and other times it's not quite so clear cut and we have to look a bit deeper into, well, what's been going on. So legally speaking, it's the date you were no longer living together as husband and wife. Now you can be under the same roof but be separated, and we'll potentially have to ask you about things like, well, were you sleeping in the same bed? Were you having sexual relations? Were you cooking together? Were you doing laundry together? What do your family think is happening? So it's the whole picture. Sometimes it's a case of, well, somebody left the house on X date and, you know, it's a really clear sort of a date. But the important thing to remember is that we look to get that date agreed upon at the very beginning. And what we then do, once we've agreed that date, is we look at what the pot of your matrimonial property is at the date of separation. So that's all the assets and liabilities that are in joint names or in each of your sole names at the date of separation. Okay. And that, when you're a married couple, that's when we look at the matrimonial pot, and that's to divide between you.
And from any assets that are acquired after that date of separation, they're not part of the matrimonial pot?
That's right, Kerry.
Okay.
Acquired after that date is not part of the pot and doesn't need to be taken into account. So again, that's why it's important to identify this date of separation, because that's a cut-off point.
Yes.
And you know, any assets acquired after that date don't fall to be included.
Okay. And am I right in thinking that there's also kind of a start date with Scottish law about when assets start to be included?
Well, that's right. So the matrimonial property is all property that's acquired during the marriage. So the date of the marriage until the date of separation. So that's the period over which we would look at what assets and liabilities each person has and what's in joint names. And also we take this snapshot of what you have at the date of separation, and that's the starting point. And the starting point in law is that there should be a fair division of your net matrimonial property. Assets less liabilities gives you your net figure. So we look at properties, we look at bank accounts, investment, shares, savings, we look at pensions, and in a negotiated settlement, what we look to do, and certainly in advance of court proceedings, we look to get vouching showing what the value is of all these assets at your date of separation.
Okay. And for a pension, then it would be the amount that had grown from the date of becoming a couple to the date of stop being a couple. Oh, actually, that's interesting. Is it the date you get married or the date you become a couple?
It's the date of the marriage, Kerry.
Yeah, it is the date of marriage. And so the pension side of things would be the amount that you'd acquired from marriage to separation. And they would take away anything that had been acquired beforehand.
That's absolutely right. So there's a very particular valuation that you go off and you get from your pension provider.
Okay.
And it's called this cash equivalent transfer value. And you go off, you give them your date of separation, and they come back with this CETV, this cash equivalent transfer value. And we look at that to make sure that if the pension has been begun prior to the marriage, that portion of the pension has been excluded from the valuation. Now, some pension providers will do that for you, some leave that up to the solicitors.
Okay.
So we have to check that, the valuation contains that calculation.
Yeah, that makes sense. And then you were talking about the basis being this fair split. Is that 50-50? Is that always 50-50?
So 50-50 certainly is the starting point. And this process of fully vouching, fully valuing, what we do is we build up this picture, what's in joint names, what's in your name, what's in his name, what the net figure is. And the starting point for the discussions is, well, what is a 50% division of the total? And then who has what in their column? What do your figures add up to? What do his figures add up to? And what does the joint property consist of? So there are arguments that can be put forward for an unequal division, and the most common of those that really crop up is there a prenuptial agreement or other separation agreement or minute of agreement which says what will happen to a certain asset or assets? Have one of you destroyed or gotten rid of any matrimonial property? If somebody burnt the antique paintings or something dreadful like that. One third most sort of common scenario is where one of you has contributed more than the other to the purchase of an asset. So that would have to have been using their income and efforts alone. So the most common example is where somebody perhaps uses something like inherited funds to put down a deposit on a property during the marriage. So that sort of thing would be reflected in the overall settlement. And if any of the properties used in connection with a business, then that's also a circumstance which might justify an unequal division in some way. So those are the kind of most common arguments that we look for early on to see whether or not we need to take into account any of these special circumstances. And it's not an exhaustive list, that there can be other circumstances which crop up for people which need to be taken account of. There are also sort of some general principles which we also apply to the division. So if a wife has given up a career to look after the children, she has reduced income and pension prospects, and the husband has gone out and worked and has a big pension pot because he's been promoted and contributed more to that, then that's something that might justify an unequal division.
That makes sense.
Yeah, there's a couple more. So will I just run through the other principles?
Yeah, that'd be great.
No problem. All right. So if one person has what we call the economic burden of looking after the kids, so if one person has all the costs of caring for the children and that's not offset by child maintenance, then that's something we would look at. Couple more for you. Whistle stop tour is what you've asked for. So
Yeah.
here we go. If one person's been substantially dependent on the other during the marriage, then that's something we would need to look at. So that might justify a payment post-divorce, and I'll perhaps come on and speak about that briefly in a moment. And the final sort of principle that we apply is where one person has had or is going to suffer serious hardship financially as a result of the divorce.
Okay.
So that allows us to look at the full picture of someone's financial circumstances and how things have been organised during the marriage.
That makes perfect sense. Tell us a bit more about the income, and then I want to ask you a little bit more about whether people can choose where they get divorced. So yeah, tell us what you're going to say about the income.
Well, this is actually something that's quite different from England that, you know, I'm quite aware of. And certainly in Scotland, you're not, generally speaking, going to get a payment post-divorce for any great length of time. So where you have been substantially dependent on your husband during the marriage, and you need to, for instance, retrain to get back into employment, and you need to adjust to your new financial circumstances, then you could get something called a periodical allowance, which is post-divorce financial support for 3 years. Up until the point of divorce, you could be entitled to something called spousal aliment, which is financial support from your husband if he has more disposable income from you than you, and that ends on divorce.
Okay.
In England, I think what you see is much longer periods of financial support, and it's much more restricted in Scotland. So, you know, if you are able to sort of decide, you know, which forum to use, you know, you need to think carefully about what might be best for you.
And can you decide then? Can you, you know, is there anything that says you have to use Scottish law if you're in Scotland?
So if you are domiciled in Scotland or are habitually resident in Scotland, then that's when you would be looking to engage Scots law for your divorce. But there's certainly been recent examples where, you know, a husband has raised divorce proceedings in Scotland, but a wife has gone to England to seek financial support. And that is possible for the English courts to make orders in relation to financial support if they can be seized of jurisdiction, is what we call it.
Okay, interesting. And it's a lot to consider, I suppose, if that is you. Judith, thank you. I think that's really enlightening. It's so interesting to see how different the two systems run. You know, it's just, you would assume they would be so similar, and they're really not. So it's been absolutely fascinating, and I'm sure really, really useful for all the women listening along. I will put your links in the commentary below. So if you want to find out more about what Judith does, please look below and you'll find all of her contact details there. And thank you again, Judith, for being such an amazing guest.
Oh, thank you so much for having me, Kerry.
See you soon.
Bye.